Good morning, everyone, and thank you for being here. On April 5th, 2015, an incident occurred in the community of Mitchell's Brook involving one of its residents, Mr. Don Dunphy, and a member of the Royal Newfoundland Constabulary and a former Premier's protective detail. That incident resulted in the fatal shooting of Mr. Dunphy. I once again extend my condolences to the family of Mr. Dunphy. This was a tragic incident. I can only imagine how difficult the past year and a half have been for all those impacted, both family as well as police officers across our province who are dedicated to ensuring our communities are safe. There have been many questions from his family, neighbours, and the public at large as to what happened that resulted in the death of Mr. Dunphy. Our government made a commitment last fall upon forming government to hold a public inquiry into the incident to ensure those questions are answered, and we've remained steadfast in that commitment. Today, in accordance with Part 1 of the Public Inquiries Act 2006, we are establishing a Commission of Inquiry respecting the death of Mr. Donald Dunphy. The Honourable Justice Leo Barry of the Newfoundland and Labrador Court of Appeal is appointed as Commissioner and will conduct the inquiry, and it will be held at the former School for the Deaf on Topsail Road here in St. John's. I am pleased to have Justice Barry join me today and would like to thank him for accepting the duties of Commissioner. I am confident he will ensure a full and complete inquiry into the facts and circumstances of this tragic incident. Also today, we are releasing the terms of reference for the Commission of Inquiry. They have been determined in consultation with Chief Justices Green and Whalen, along with Justice Barry. It is critical that the family and the citizens of our province be provided answers to the many questions that remain regarding the facts and circumstances of Mr. Dunphy's death. Under Part 1 of the Public Inquiries Act 2006, the Commission will act independently in determining who will participate and how, and what evidence will be part of the inquiry. It will allow for a full and complete review of the facts and circumstances of this incident. We understand that the independence of the Commission is important to building and maintaining public confidence in our justice system. The terms of reference will allow the Commission of Inquiry to delve into the many areas of this incident that have been so troubling for the family and for our police officers, the dedicated women and men of our police forces, and for the people of the province in general. The legislation gives broad authority to the Commission to determine its own procedures. It is required to give persons who believe they have an interest in the subject of the inquiry an opportunity to apply to participate. Under the legislation, the Commissioner then determines who may participate and how evidence is to be received, which could be in writing or through public hearings. The Commission also has the power to issue a summons to compel a person to attend the hearing or produce a document. This is of critical importance given the frustration and disbelief by so many that the various reports related to this incident have not yet been released. Justice Barry will begin work immediately and will deliver a final report to government before July 1st, 2017. There have also been questions regarding Mr. Dunphy's history with the workers' compensation system. Following consultation with the Dunphy family's lawyer, we are referring the history and treatment of Mr. Dunphy's case by Workplace NL to the Office of the Citizens Representative for investigation. This investigation provides an avenue for this review to be conducted while still maintaining the focus of the inquiry. We have requested that the Office of the Citizens Representative begin the investigation immediately. It is not lost on me that it has taken far too long to get to this day, and it's unfortunate that we need an inquiry in the first place. Over the past number of months, it's become abundantly clear to me that our province and justice system would be well served by having its own serious incident response team, an independent team. But in the meantime, I am confident that this inquiry will provide answers. Again, I would like to thank Justice Barry and the Citizens Representative, Mr. Barry Fleming, for taking on this important work, and I look forward to receiving the reports. And at this time, I'd also like to pass along my thanks to the Department of Justice, my colleagues and staff, for their tireless work over the past number of days and weeks to ensure that this could happen so quickly. They've been working around the clock to make this come together, so I thank them for everything that they've done as well. And at this time, I would now open the floor to any questions from the media for myself or Justice Barry.
Why did you choose Justice Barry for the inquiry?
Well, there's a protocol that dictates that in these cases, if you go with the Public Inquiries Act, you must go to the Chief Justices, which I did in this case. I went to Chief Justices Green and Whalen, and they, again, quickly took this on and came back and Justice Barry volunteered to take this on. Again, we're very appreciative of that.
Justice Barry, when do you plan to begin hearings?
Well, we've already begun in one sense in that I've been involved in looking at the School for the Deaf to determine whether it's an appropriate venue, and I've had some input into the terms of reference in terms of how they're drafted.
Will you include information from previous investigations on this in your inquiry?
I have to preface everything I say that in terms of I'll be seeking input from counsel for the participants before taking final decisions on matters such as this. But yes, it would seem to me what's happened in other inquiries will be helpful. I've already found particular help from a decision published in the course of the so-called Luther inquiry, where they discuss the procedure to be followed by a commissioner in carrying out a public inquiry.
Mr. Parsons, you said that the inquiry will not express a conclusion or recommendation regarding the civil or criminal responsibility of any person. Can you then give us a sense of what the inquiry will be able to do?
Well, the first thing, obviously, is the inquiry is designed to answer the many unanswered questions that have been out there about the facts and circumstances. I've talked about this on a number of occasions. Right now, we don't know what happened or why it happened. All we know is that there's an individual that's dead. The second part of this, and that what you would hope to take from an inquiry, is that it will come up with the facts, and then it will come up with recommendations on how to prevent these things from ever happening again. So I would assume there will be a report delivered with recommendations, which we'll see at that point.
Justice Barry, will you be releasing the RCMP reports and the ACER report and retired Justice Rich's report as part of this inquiry?
Again, I haven't seen the reports or received the reports. It would seem that the reports you refer to will have some relevance. I will await the input of counsel in some respects, but I would hope that all the information available to this point would come to the Commission and ultimately would be available for the public viewing. I have to caution that we have to keep in mind privacy concerns and certain concerns respecting ongoing investigations, if there are, and so forth. I can't give you a blanket answer today on that.
The RNC Association is calling for the release of those reports ahead of the inquiry. The RCMP says it won't do that. Would you have a problem with those reports coming out ahead of the inquiry?
Again, I can't take a position on it until I determine what the law says with regard to access. Like any commissioner, I will have some wide-ranging powers to subpoena if reports are not received. Parties will have the right to respond to subpoenas if there are concerns about whether or not the report should be released, and I believe that it's appropriate to follow the practice as determined by law and to have input from the parties. That's assuming that the ones in receipt of the reports you refer to do not make them by agreement available to the Commission. So at this stage, I wouldn't want to speculate that there's going to be a refusal. I haven't heard any response by the RCMP I did hear the suggestion in the media that the RNC Association wanted the report released. I haven't seen any complete response to that.
Is there still a possibility that the officer involved in this incident could face charges?
Again, as far as this commission is concerned, the Public Inquiries Act provides that commissioners do not take a position with respect to criminal liability or civil liability. But if there are facts revealed in the course of an inquiry, then obviously these facts would be made known to government and to the powers that be in terms of making decisions, and it would be up to them as to what the law says in terms of acting upon any new information received.
Retired Justice Rich raised his own concerns about the RNC's conduct and the RCP investigation this week. Do you have any thoughts on what he said this week?
I don't want to comment specifically with respect to Justice Rich, other than that I'm at a bit of a loss as to why that procedure was followed. Justice Rich was not operating under the purview of legislation such as the Public Inquiries Act, and to that extent, his opinions are his own. So I think you'd have to deal with him in terms of whether or not the opinions stand up. I will say that I will be dealing with evidence that's presented under oath. I will not be dealing with my own recollections or information I may receive informally. It'll be, as in any public inquiry, my responsibility to hear from counsel as to what the significance is of various facts that may be provided, and it will be my responsibility to make sure that any recommendations I make are on the basis of firm, hard facts and not on my own opinion.
When you say you're at a loss why that procedure was followed, which procedure do you mean?
Bringing in an individual to overview what the RCMP was doing, which, as far as I know, again, I only know what's been in the media. I'm familiar with how the RNC or the RCMP would proceed in determining whether or not to lay charges. I'm not familiar with the policies. I probably will become familiar with it, but I'm not familiar with the policies or procedures that are employed by the RCMP in order to make sure, as I take it, that they are investigating properly.
So, Justice Barry, are you suggesting that retired Justice Rich shouldn't have commented the way he did in the media?
No, I have no opinion regarding whether or not he should have commented. He may not be operating under a legislative direction, but he may be entitled to express whatever personal opinion he has in the events that occurred.
Minister Parsons, did you have any thoughts or concerns on what Justice Rich said this week?
Again, I guess the big concern that I hear, not so much about that, has been about there's been dribs and drabs of information coming out here. We don't see the release, and I think that's contributed to the overall situation we have, which is a year and a half of uncertainty and a family not knowing. And I think what I've done as the minister, and my responsibility is to hold an inquiry to get to the bottom of everything. And along those lines, that's why we're extremely happy that we were able to get this moving so quickly. I think in the grand scheme of getting the report was released to the RCMP, moving this forward, and getting someone like Justice Barry to come in and oversee this so quickly. These things have taken quite a bit of time in the past, or to get commissions up and running. So to be able to move so quickly, I think that's what's in the best interests of everybody, especially the family.
Mr. Parsons, do you have any idea how much this is going to cost?
We've budgeted between $1.5 and $2 million for this inquiry. That's what we've calculated, looking at the different costs, the logistics, looking at previous inquiries. That's what we're anticipating the cost will be in that range.
Can you say who sought funding from legal counsel?
Again, we've had 2 people, and I'm assuming that there will be more. People will apply for standing. Again, when it comes to witnesses, I don't know how that works, but people will apply for funding for counsel. And right now we've had 2 applications, one by the family of Ms. Dunphy and one by the former Premier.
So former Premier Paul Davis and Megan Dunphy have applied for standing?
For coverage of the legal counsel.
Did you have any sense of what other groups or people have applied for standing?
Not yet. I haven't heard from anybody, and that's something that, again, that will go through Justice Barry as the commissioner.
The deadline of July 1st, 2017, less than a year away, do you believe you can realistically get the inquiry done by that time?
I'm hoping that it would be earlier than that. That's the drop-dead date, as they call it, but I don't envisage that it should take that long. But again, I'm fresh at this, and I'll have to hear from council. I may be overly optimistic in terms of what council may successfully argue as to where we go. But I think generally it's recognized that you should stick to your terms of reference. If you don't stick to them fairly tightly, then things have a habit of running out of control. And we'll make sure it'll take however long is necessary to do the job thoroughly.
Do you know who your inquiry counsel will be yet?
I'm in the process now of considering individuals, contacting individuals, and I can't make any more comment than that at this time.
Why was the workplace compensation part of it separated and given to the citizens representative?
Well, we felt on a couple of levels. I guess the first thing being that when it comes to Mr. Dunphy's file, I'm sure that has quite a bit of personal information, private information, health information. And we felt that maybe a public inquiry was not the best place for a person's file to be brought into scrutiny. But at the same time, we realized the importance of this matter to the family. So that's why we went with the citizen's representative route. He has legislative authority to be able to look at this, to be examine it, do a full examination of this file and this particular issue. The other side of it is that we think we have an inquiry that, as broad as it is based on a specific incident. And we felt that if we went down that road of bringing workplace NL, workers' comp, into this, that it could quickly spiral out of control. I know there's a number of individuals, I'm sure, in this province that have had issues or situations involving that, and we felt that in terms of time, in terms of cost, in terms of, it could go away from what we felt was the crux of this matter, which was the incident that occurred back in April 2015.
The terms of reference also looked at or refer to who may have directed the RNC officer to go to Mr. Dunphy's house. So do you see this inquiry looking into what happened in the former Premier's office?
I have no idea where it's leading until I hear from council and they make their submissions. But I would expect that we'll have to do everything we need to do in order to see that all the facts come out. In whoever's office, it doesn't really matter where the information is held. But again, there are, as I understand it, possibly arguments that might be made with respect to which evidence is available to us and which by law is not available. And I'll follow the law, but I'll try and, as far as possible, get all the facts on the table.
Mr. Don Dunphy had a very public frustration with the situation with workers' compensation and his involvement with the system. Will this inquiry have any, will it be so narrow that it won't involve the circumstances that led to his frustration that made him reportedly upset?
Again, I'll have to have council submissions and decide on those, but it seems to me that there are a number of the terms of reference that would require us to consider what grievances Mr. Dunphy had without getting into whether or not he was treated properly or not by the commission, at least as I see it at this stage, subject to what council might say. We're not in a position to go back over years and years of, if that's what occurred, applications for assistance which may have been refused. There may be decisions that have already been brought down that could have been appealed, maybe were appealed, I have no idea. So it's not a commission, as I understand it, on the operation of the public, the workers' compensation legislation. It's, as the minister has said, more specific than that. But I would, again, subject to what council has to say, anticipate that I will have to look at what grievances, if any, Mr. Dunphy had that related and are relevant to the events that unfolded.
Justice Perry, a number of people have said they don't want to speak before the inquiry because they're concerned about tainting the process. Do you see any merit to that concern?
Well, again, that's a very broad question. I think usually in a sort of public incident like this, there is an attempt made to get the facts out while keeping in mind that there's often two sides to a story. And that's why in the terms of reference, there's a note as to what the commissioner will be considering as I proceed, and it's on the one hand making sure that the general public is confident in the administration of justice and in the maintenance of law and order, while at the same time keeping in mind the necessity for having police officers protected, for example, in the course of their work. There are cases, and I've dealt with a number of cases that involve criticism of police activity. You often get them in the course of deciding whether the police operated properly in search and seizure situations. And Supreme Court of Canada has referred fairly recently to what they see as a fundamental bargain which is made between society and the police, between government and the police, as it were, that they expect the police to do their job while at the same time making sure there's a minimal intrusion into the lives of the ordinary citizen, but also the police are entitled to expect that society will see that they are protected, and there's a concern for officer safety in the course of these types of investigations. So that's all I can say, and that's in a very general sense. I have no idea in this case yet, until I hear the evidence that legally should go in, as to whether there was concern, for a legitimate concern for officer safety in this situation.
But would any of those people, speaking out, could that taint the process? Are you concerned that if, say, a police officer would speak about his involvement, that would taint the process?
It depends, I guess, upon the types of information. If you're dealing with, I'm just again thinking speaking theoretically, if you're discussing the evidence of children in an inquiry where children may be testifying eventually, there's often a concern that because their memories are weak, that they will adopt as their memory the last thing or more recent things that they heard. So in that sense, yes, evidence can be tainted, but when you're dealing with adults and you're dealing with fairly straightforward information, arguably there's less concern. But again, you don't want individuals tailoring their testimony to sort of fit the objectives of some individual who they've heard discuss it. So I know I'm speaking very generally. That's intentionally so, because in this case, I just don't know whether getting more information out there would taint, put that in quotation marks, testimony that will be delivered to the Commission. I don't know if that helps you.
Is there a chance that that information could be released throughout the process of this inquiry?
Well, I'm going to be going for receipt of all information that is relevant, and that's what I'm required to do under the Public Inquiries Act. So if anybody comes forward with a position that, no, this information should not be released, they will have to justify that as a matter of law, why that is so. And it won't be done in some very, arguably, it will not be sufficient to put out some sort of general notion that it may taint the process. I'd want to know how and why. And there's a subpoena process that's available. If somebody has a legitimate reason for refusing to release information, they'd be entitled to challenge a subpoena. So there may be legal arguments that will develop where I'll have to hear counsel in that respect. That we have to keep in mind also that these types of legal arguments may lead to more time being taken in the completion of the report, but at this time I think we can handle it in the time allotted.
Mr.
Well, that's something that we'd have to deal with, obviously, if we got to that point, we would consider it. I think commissions of inquiry in the past have had requests for extension and granted them. But right now, as it stands, Justice Berry has indicated he's quite confident that the June 30th deadline will apply, and it's something we, like anything, we'll deal with it as it comes. Unless there's any other questions, again, I'd like to thank everybody for coming here today. And I'd like to thank Justice Berry, as well as Chief Justice Green and Whalen for making this happen, allowing Justice Berry and Justice Berry for agreeing to take this on. We want an inquiry that at the end of the day puts all the information out there to answer the questions, and that's why we felt it's so important to call this today. So thank you for taking the time to be here, and enjoy your day.